Hi, Angelo Pepa here, and I've never ever been more excited to present anything in my entire life as I am the award-winning graduation day DUI crash movie and Elm Reality Trial by Jury teaching method.
I'm fine.
You almost hit that range.
Look at you.
In a moment, it all changed.
Go back.
You know, today, our students face a lot of different problems, emotional, peer pressure, and of course, the ability to force their emotions into whether it's alcohol or drug related. Our program will help you guide your students, guide your children into the programs that we feel are so important. We've done all the research. We have all the experts involved from the medical, the legal, and the educational industries. We feel this program, from a preventative measure, will ensure your students, your children, have a future and become an important part of our community.
Not my child. If I can tell you how many times I've heard that. Parents don't want to believe that their child is struggling with drugs or alcohol. And I'm here to tell you, with over 15 years of experience in the substance use disorder world and mental health world, that they are suffering, and they're suffering in silence. This is not attacking you as a parent. Life is hard, and it's even harder for our children these days. As part of Elm, we have come together with experts from not only the education world, but legal and medical, and we are providing a program to your school district and the many school districts across the United States. We see that these children don't know how to support themselves to get through the trauma of life, so they turn to drugs or they turn to alcohol. And when you say not my child, well, when you get that knock on the door, you have a cop standing there telling you you just lost your child, or your child has been arrested for driving under the influence. These are the situations we never want you to face, and it's very important that you set aside time. Take a vacation day. Don't take that meeting and attend one of our meetings, because this could be the very thing that can save your child's life. We want to teach you how to have the conversation. We want you to pay attention to the signs. We don't want stigma to take you and make you afraid to talk to your child, because you will not get a second chance. You know, you buy your children all kinds of gifts to try to make them happy in life. You give them an allowance, you buy them surprise gifts, and that's so wonderful. But the last thing I want you to purchase for your child is their casket.
I'm Judge Thomas Durr. I'm retired from the Court of Common Pleas of Butler County. I was a district judge in the late 1980s and early 1990s for 5 years. I was elected Common Pleas judge in Butler County in 1992 and retired in January 2022. I attended Butler High School, graduated, went on to University of Pittsburgh for undergraduate work. I then attended Capital University Law School in Columbus, Ohio. After graduating and passing the bar, I came back to Butler, started a general practice, and then moved into the judging area with the district judge position, and then eventually the Common Pleas judge position. To the kids who may be watching and the students, it's important that you become involved in this process for a number of reasons. It may provide you with the key to understanding what you want to do with the rest of your life. It's also important that you understand the issues involved. Hopefully understanding those issues will keep you from going down the wrong road. You need to understand, as you're driving down a road, you have something that's called an illusion of immunity. Nothing's going to happen to you. And you need to understand that at any point that illusion can be broken. You can drop off the road and lose control. Things are much more likely to happen if you're under the influence of any intoxicating substance, or if you're not paying attention because you're paying attention to somebody else in the car or your phone. And the consequences can be fatal. And if they're not fatal, they can be painful. Take it from somebody who's had, some major injuries in life. You need to understand that you may very well end up living the rest of your life with consequences from your bad decisions, and you need to think about these things and make appropriate decisions.
Our defendant here is charged with, do you remember the probable cause sheet? I have it, the prosecutors are coming. Our defendant here is charged with DUI, but he's also charged with DUI homicide, or homicide by vehicle DUI related, I think would be the more proper way.
Correct.
That might sound like it's the same thing, but it's not, is it?
Well, typically in a case where there's been an accident and somebody has been drinking or using drugs, the charges would be where a death resulted to a driver of the other vehicle or an occupant of the other vehicle or the driver's own vehicle. The charges would be DUI, homicide by vehicle, and homicide by vehicle while driving intoxicated. The last two are two distinctly different offenses.
And they have different, distinctly results for a defendant too, right?
They have different elements, and the different elements that would have to be proved for a conviction of each.
What would be but we'll go back to the elements, but what's the difference in the punishment for the two?
Well, the homicide by vehicle while driving intoxicated has a minimum mandatory, and in the year I retired, it could have changed, but as I recall, it was not less than 3 nor more than 6 years. It's 3 to 6 years in jail.
And I believe it's still the same. We'll have our prosecutors go over that later, but we're talking about, it doesn't matter if this person is a kid in high school. He's got to do that jail time, correct?
If it's a kid in high school, depending on the age and the circumstances and the background, it could be charged as a juvenile offense, and I have presided over those with juveniles, or if there's reason, it could be charged as an adult offense.
And again, that's a question of the prosecutorial discretion, because once the charges are filed, the prosecutor, if he wants to, has the ability to at least attempt to have him tried as an adult, correct?
That is correct.
So if that person loses that argument with the prosecutor, he will be tried as an adult, which means that even if he is a high school student and he's found guilty, then he probably would have to do the mandatory minimum in jail.
That is correct.
I want to make sure everybody gets that.
Yes.
So that's certainly one of the exposures out there. And of course, now the other one, DUI, is the second one you're talking about if he's found guilty of that and not DUI, homicide, DUI related, then of course we don't have a mandatory minimum in that. We'll get into those issues later. What the punishment is.
And the difference is, to be charged with homicide by vehicle, you had to commit something that was more than negligence. You had to be grossly negligent or criminally negligent. For instance, if you're driving at an exceptionally high rate of speed, if you run a stop sign, if you're racing on the highway, those would be elements that would go to a homicide by vehicle. Whereas with the homicide by vehicle, DUI related, no negligence on your part is required. You can have a homicide by vehicle where you were drunk, operating a vehicle and not necessarily at fault in the accident, but if as a result of the accident the person in the car died, it may make the charge of homicide by vehicle while driving intoxicated.
Al Lindsay is our defense attorney, but Al Lindsay played a role in you going to law school somehow. I think you remember telling me that.
That is correct. I told you that my family had been involved in politics, and my older brother was an attorney. He was 30 years older. So when I was in high school, through the Boy Scouts of America, I was an Eagle Scout, but in addition to that, I was in something called an Explorer Post. And Al Lindsay, John Vierthaler, and Bill Kemper, three of the young attorneys in Butler County at the time, were the advisors for the pre-law explorer post. And there were a number of us, Tim McCune, who is now Judge McCune in Pennsylvania, former DA, and a couple others who ended up going on to law school, were in that pre-law explorer post. And, I was interested in doing that, having grown up in the family I grew up in, but that was what made me focus, that helped me determine that that's what I want to do. So Al was a very big part of that. He had some big cases going on at the time.
I think he was a U.S. attorney for a while.
He was a district attorney in Butler County and then a U.S. attorney.
And then he's in private practice, and we know that's taken him all over the place. And he taught trial tactics in the University of Pittsburgh for 30 some years. I don't think he does that anymore. And in your background, Your Honor, where did you go to law school?
Well, let me go back to trial tactics for
okay.
1 minute and Al
Sure.
Lindsay. So where Al Lindsay learned many of his trial tactics was from the first chief public defender of Butler County, a gentleman named Mike Mamula. And you can talk to Al about this, and please do. Mike was such a good attorney. When you would go in and watch him in trial, it would be as if you were watching a produced movie. He was so good at cross-examination. He was so good at direct examination. He understood human nature so well. So while Al was a young district attorney going against the public defender in trial after trial, he learned many of his trial tactics from Mike Mamula. So it's interesting. And I had gone to Pitt for my undergraduate degree, and then Capital University Law School in Columbus, Ohio. So I came back. Because my oldest brother was 30 years older, I had a nephew a year older than I am who had just graduated from law school, went into practice with my brother, so I went in with Mike Mamula, who was a family friend. And that's the way the whole thing kind of got started. But it was interesting, going down and watching Al and Mike square off, because they were both so good at what they did.
And it came some kind of an inspiration for you, I guess.
Oh, very much.
Yeah, and then taking this one step further, that amazes me is that you're about to be our trial judge in the Graduation Day movie and a DUI situation, but you actually had a real case like that as a defense attorney?
As co-counsel with Mike Mamula, a defense attorney, as far as I know, it was one of the first cases, if not the first case in Pennsylvania to go to trial under the homicide by vehicle while driving intoxicated.
In this particular case, okay, we have a person charged, and you're going to be the presiding judge. And we've got you to agree to that, and we really appreciate that. Okay, now we're staying away from those facts because that'll be a trial.
Yes.
So we're not going to apply that. However, this issue comes up. And the issue again is a criminal issue. In our fact pattern here, the driver of the car is our defendant. And in the movie, the defendant was killed. Okay? But in our scenario, we took author's license. He's paralyzed from the waist down, and he's charged because there was somebody else in the back seat that was killed. Okay. Now, having said that, the prosecutor, and I'm going to go all the way back in your extensive background again to lay this out. The day that accident happened, everybody's in a hospital, probably nothing happened. Within a number of days, the police started talking to people when they could. And the first thing in the criminal justice system is the police officer didn't like what he heard or she heard. And so can you help us a little bit in what you know the police officer probably did next after he took a report?
Well, what a police officer does after taking a report, the first thing they want to do is they want to talk to everybody to get everything they can every potential fact, because if you're lying, it's generally going to come out. So, you need to be brutally honest if you're a witness to an incident and describing what happened. The other thing that an officer will do in those areas are they reconstruct the accident in great detail. And so they will take precise measurements. They'll analyze everything. They'll get samples. They'll send them off the labs. They'll get it back. In a case where somebody has died on a vehicle, there's always a very intensive investigation that generally leaves no stone unturned. I've seen cases over the years where the vehicle was identified based upon parts of a parking light that were left behind, and they were able at some point to determine that was the vehicle that caused the accident because of the pieces of the vehicle that were left behind.
And sometimes the police actually will cordon off the crash scene and not allow it to be towed for a while, correct?
Yeah, it's very
And again, they're
common.
preserving evidence. And then the next thing is, too, the reason they want to get right on these interviews is they want to get it while it's fresh in people's minds, correct?
That is, they want to get it while it's fresh in mind, correct. One of the things I do after having been sitting through so many cases for so long, anytime I see an accident that I'm a potential witness, I used to grab a piece of paper and a pen that I kept in my car. Now I dictate a note into my phone, and I state exactly what I remember seeing at that time. And if it's at a traffic light, I'll stay there and watch to make sure that the light is cycling correctly in case there's a dispute as whether the light was not working. And then I'll usually make it a point to give my name if there's an officer that shows up to one of the people involved in the accident. I'll usually approach the person who I believe was not at fault, say, here's my name, here's my phone number, this is what I observed happen. If there's any issue, feel free to call me. And I believe that's my duty as a citizen.
And I'm so glad you said that, because that's one of our messages here to the parents and adults out there, regardless of what profession or no profession.
Yeah.
That's kind of a civic duty that you should do that. I can't tell you how many times I've heard things that sounded like gunshots in the middle of the night, and I'll wake up and I'll actually write down what I heard and what I thought I heard, just in case it becomes relevant later to somebody. So it's having done that, the police now have this stuff that they've accumulated. What do they generally do next, if anything?
Well, they make a determination as to the identity of a defendant if they believe a crime was committed, and if they believe a crime was committed, is there sufficient probable cause that the crime was committed? And if so, what crimes were committed?
And they go back to their office, and just like we see TV movies where some policemen are typing with one finger, they type up the probable cause sheet.
And some of them are still typing by hand. Other ones, use computer systems.
And then that person isn't charged yet. What happens next? Generally.
It takes a period of time. It can take a week, it can take a month. They can be waiting for lab reports to determine whether they have sufficient probable cause. So, in a homicide case, not necessarily a homicide by vehicle, where there's a perpetrator, an accused perpetrator who could be a danger to the public, they're generally going to file charges at that point. They're authorized under the rules of procedure in Pennsylvania to immediately take the person into custody. If it's a type of offense such as a DUI, generally you're not taken immediately into custody in the sense that you're going to stay overnight in jail, but depending on the circumstances, you may be. You can, in appropriate cases, be released to a family member.
So back to our, not this case, but one like it.
Yeah.
This is not a murderer who's out there being stalked by the police to protect people. Once the information is assembled, the police don't charge him, do they?
No, the police file the initial charges. They file the complaint.
Do they take it to the district attorney before they do that?
Depending on the rules of procedure, some district attorneys in Pennsylvania have elected to be able to approve all charges In other counties, it's only a certain type of charges. For instance, the police can file any misdemeanor, but in order to file a felony, it has to be pre-approved by the district attorney.
So to charge somebody homicide, DUI, homicide related, it would probably have to be approved by the DA.
In most counties, yes.
So now the file, I'm imagining, ends up on the DA's desk, and that's what we call prosecutorial discretion.
That is correct.
We hear a lot about that in political sense right now on TV, but the prosecutor has the discretion to not charge also, correct?
That is correct.
And he has the discretion of what to charge.
That is correct.
Okay, so in our case, let's assume that the prosecutor has chosen to file charges, homicide-related DUI.
Yes.
And he's going to charge the lesser included offense DUI, right?
Yes.
Probably. Okay, so that now gets sent to the defendant by certified mail, or do police bring it? Do they go pick him up?
It depends
And I know
on
it
the
depends. That's
circumstances.
what I was hoping you'd say.
The general rule in a DUI is you're going to be served by certified mail at a later time. There have been cases, back in my district judge days over 30 years ago, I can think of a homicide by vehicle case where the defendant was taken into custody immediately that night.
And that goes back to generally the safety of the community to prevent a second occurrence or something like that.
Yes, as a judge I practice in front of, and a line I've used many times myself, the public has a right to be protected.
So, and our prosecutor, you weren't there at the preliminary hearing, our prosecutor argued for a higher bond, saying that this guy's liable to drink tonight and go out there and hurt somebody else. And that's resonated, that the magistrate got that and made the bond real high. So that would determine how and when the police would pick him up, probably.
Correct.
And again, we're speaking generally here.
Yeah.
Okay, so having done that now, he's charged, he may have gone into custody, and then there'll be some kind of a bond discussion, I would think, at that arraignment. Mm-hmm. And the magistrate would arraign him,
Yeah.
and we talked about that. Or if he's not, and it's sent certified mail to him, he would not be picked up.
But he would have to appear in court, and if he failed to appear, then a bench warrant would be issued for his arrest.
Because of the potential safety compromise of the
Well,
community.
anytime you don't cooperate with the system by not showing up, there's going to be a bench warrant.
So,
And they never go away. So, just anytime you get legal process in the nature of a criminal complaint, it never goes away over time. You have to respond, and if you don't respond, there will be a bench warrant issued.
3 weeks ago, I was in Fayette County to vacate a warrant that was 14 years old from a driver in Texas who got stopped at a red light.
Yes.
He'd never been in Pennsylvania in his life except for one day 14 years ago. Anyway, so yes, they never go away.
They never
and these
go away.
computers now in the police cars, they pop up.
Yeah, and there's a circumstance I know where somebody was being a good Samaritan, observed something going on, called the police to respond to a public disagreement, and as good policemen do, they get everybody's name and phone number and address as potential witnesses, and it turned out that, lo and behold, about 15 years before, he had failed to respond to something relatively minor, and he just thought that since he had grown up, he was an adult when it happened, but since he had gone to college, grown up, had a job, and was living happily ever after, that it had somehow gone away, and it didn't. He ended up spending the night in jail.
And even a parking meter ticket could turn into a warrant.
Even a parking meter ticket can turn into a
And
warrant.
certainly a speeding ticket, if you never responded, would turn into a warrant.
Yeah, it's speeding tickets. There's a statewide computer system with all the district judges' offices, so if you don't respond to the ticket, your license is going to be suspended, and there's going to be a bench warrant issued for your arrest.
And you might have been speeding 1 mile over the limit, but if you don't respond, not only does the warrant come out, the license will be suspended.
Correct.
And then when you get arrested again, when they enforce the warrant, they're going to add the new charge of driving while suspended.
Yes.
Okay, this is all things we want parents to know about. Okay,
Yeah.
well, going back to our case here. Back in our case, this person Well, clearly, he probably already has been arraigned, and arraignment is basically telling the person what they're charged with.
Yes.
I-
They're
I-
actually, at arraignment, they're actually handed a copy of the charging document. They get the paperwork.
And I always liken it to being out on a date, or even, I'm not going to say this ever happened to me personally or with my wife or anything, but all at once you're talking and your words aren't coming back to you anymore. And you realize the person you're eating with is not speaking to you. You have no clue why, but there's nothing coming back. You have not been arraigned. So the arraignment is certainly valuable to tell somebody what they did wrong, or at least what somebody thinks they did wrong.
What they're accused of having done wrong, and then setting bond.
And of course, that would be there, driving under the influence, and then another charge, top one, leading charge probably is on top. Driving while under the influence, DUI, homicide related, or whatever configuration of words.
Yes.
Okay, great. So now, in our case, this person has been through that and actually has been through the preliminary hearing. Now, if you could help us, again, you've been so helpful, and I appreciate your patience. I'm breaking it down elementary-wise because people, I want them to know,
Yeah.
even for high school classes.
Yeah.
So, at the preliminary hearing, what is a preliminary hearing?
As I mentioned earlier, a preliminary hearing has two primary purposes. One is the person before the court, is that the person who committed the crime? It's an issue of identity.
Okay.
So is this the person who's accused, or is the appropriate person accused? In most cases, there's not a bona fide issue of identity. In some cases, it is. But most cases, the identity is known of the perpetrator. It's not disputed. The other issue is, did the police have a reasonable suspicion, probable cause, that the crime charge was committed? And that would be a factual statement provided as to each and every element of the charges against the defendant.
And the policeman would need to be there.
Oh, the policeman needs to be there. Generally, what happens is that either a defendant admits that there's probable cause and waives the case to court, or there's something called a preliminary hearing. The police and any witnesses have to provide testimony to establish that, in fact, there is probable cause, or that there may not be.
And the testimony, for the most part, and I know a magistrate's a little bit different, but the testimony needs to be proper testimony, from the experiences of the witness, and somebody could object to that, but whatever is admissible would need to say that it's reasonable that there's sufficient evidence here, correct?
That is correct.
And it is rare that defendants ever testify at preliminary hearings, correct?
That is correct.
And why do you think that is? You were a defense attorney once upon a time, too.
The reason defendants don't testify is that any statement that they make can and will be used against them. So if there is any inconsistent testimony at trial, the prior testimony is a tool that can be used against the defendant.
And of course, if we know nothing they say, well, first of all, it can be used against them.
Yes.
But we also tell the defendant that nothing you say is going to change this outcome of the preliminary hearing anyway if it's sufficient, correct?
That is correct. It's not really a question of credibility between the Commonwealth and the defendant. It's a question as to whether the evidence presented by the Commonwealth is sufficiently credible to establish a reasonable belief that the crimes charged were committed.
And generally speaking, the law does not allow the magistrate to say, I believe the defendant and not the policeman. I don't think they're even permitted to do that, are they?
The standard is not who is more believable, the defendant or the Commonwealth. The standard is, did the Commonwealth present an appropriate amount of evidence to establish the elements of a crime, a reasonable belief that those elements were committed.
I have used the explanation of the only time the magistrate might be able to do that is if the policeman testified that the defendant was driving a spacecraft from Mars at the time. he probably wouldn't be able to believe that.
No.
We have the preliminary hearing. We know what a preliminary hearing is. I've heard the word, and I know it's confusing for some people. What's the difference, if you know, between an indictment and a preliminary hearing?
A preliminary hearing is the general terminology. An indictment can refer to two different things. There's an alternative method of charging in Pennsylvania, which would be through a grand jury. And you hear that more in federal cases or in political cases, where rather than going through the process that we've talked about, a grand jury would be convened, the prosecutor would present the evidence, and the grand jury would then make the decision that the prosecutor, the district attorney, normally makes on his own as to whether charges should be filed, and if so, which charges. And that would be an indictment. An indictment would also refer to what happens after a preliminary hearing when a case is held for court or waived to court, and it's what would be handed to the defendant, the official paperwork in the Court of Common Pleas. So the complaint that you receive before the district judge or the magistrate judge, technically it's a district judge in Pennsylvania, would be the charging document, the complaint. The indictment is referred to as a document that you get in the Court of Common Pleas.
So would the indictment process skip the magistrate?
Yes.
So the
indictment
person
process.
would get the documents just like he got the documents after the preliminary hearing,
Yes.
generally speaking.
Yeah. If there's a grand jury, it skips that whole process.
Can a person under these, could this person have been charged by indictment rather than the magistrate? I mean, they probably wouldn't, but could it?
Theoretically, yes, but it would not happen. And again, going back to, there's so many cases compared to the court staff, the district attorney staff, there's no reason for it to be done.
And it sounds like the indictment process is something where it would be more factually complex.
Usually factually complex and potentially publicly at issue, where rather than having the opinion of just the district attorney making the decision as to what charges are appropriate, it would be best to have the community, through a grand jury, assembled to hear the information and make the decision as to what charges should be filed.
Now, the grand jury would be made up of lay people, correct?
Correct.
Is there somebody who advises them on what the ranges are on the law or anything? Do they have any assistance that way?
The assistance that they have is offered, it's a one-sided trial,
The
essentially.
DA.
The DA, the prosecuting attorney, would present the evidence and the elements of the charges that he wanted the grand jury to consider to make an indictment.
And the reason I bring that up is twofold. Number one, to let people know that there is a system out there, and that's what it's
Yeah.
called, and that's why they didn't hear it here. And the other thing is, that you hear a lot of it in, as you say, in these political things now, who they want to charge with crimes and whatnot. So that would be a classic case where it would go there. But
Yes.
the DA actually still has a role because he presents the request to the jury to charge somebody, doesn't he?
That is correct. He presents the request to the jury.
And again, going back to the idea that there's no reason for a defendant to testify at a preliminary hearing, i.e., everything you say could be used against you, and it's very unlikely that it'll change the outcome. In a grand jury situation, the defendant isn't even allowed to be there. They don't even know it's happening.
That is correct. And theoretically, they could be called to testify, but it generally not happen. And they could decline to testify for constitutional rights to remain silent.
So, going back to make a point, if you know the defendant doesn't even know there's a proceeding going on about him in the indictment process, and if you know in the preliminary hearing process the magistrate is going to believe the policeman, it's very unlikely that a defendant will not be bound over for trial.
Generally true. There are circumstances where the police don't have sufficient elements for all the crimes charged, and they don't hold every case for court.
So my point is,
It's not a rubber stamp process.
right, so my point is, just because it was bound over, the Commonwealth has a long way to go to convict the person.
That is a very good statement. There's a big difference between probable cause that the crime was committed and the defendant did it, and is there proof beyond a reasonable doubt of each and every element of all the crimes charged.
So that sets us up for the jury trial in this case, Your Honor. This basically is going to be a situation where this is a situation where the big show or the big dance is coming up
Yeah.
in the jury trial.
Yes.
And we start with, I always like this picture. I saw it on a judge's wall one time when we were in chambers. It showed a little boy with an ice cream cone, and it was melting over his hand, and he was about, say a yard high, and it showed this gigantic bench with this stern judge, and it said, and it was just captioned, "The presumption of innocence." And every human being in this wonderful country we live in, despite what happened at that preliminary hearing, is presumed to be innocent, correct?
That is correct.
And that presumption lasts how long?
The presumption, the way you say it is the defendant is cloaked in the presumption up to and until the jury has been charged and has made its decision.
Unanimously.
Unanimously. So the presumption continues up until a unanimous finding by a jury that the defendant is guilty.
And that means all 12 of them.
That is all 12.
If one of them doesn't, the presumption does not disappear.
Correct. That would be a mistrial. It's not a finding of not guilty.
And and of course, we know many times that judges send juries back and forth to try to resolve that.
Yes.
But if that's never resolved, then there is a decision on whether the prosecutor wants to do it again or not, and that goes back to prosecutorial discretion, right?
You are correct.
Okay. So now, in this particular case, the jury is not going to have an easy task, I would believe. Now, again, you don't know the facts of this case, and we're not going to take you there yet because you're going to be the trial judge. And by the way, I have to ask you this. We see your robe draped over the chair there.
Yeah.
And we see that you're always very fashionably dressed. You're dressed in a suit and tie without your robe on. What's the significance of that?
It's decorum. It's tradition. It's deserving of respect. My wife is an attorney, and the first time that she was in a courtroom after we were married, and they announced, please rise for the Honorable Judge Durr, she stood up and started laughing because it was just
Too surreal.
yeah, and she reminds me of that occasionally. So it's simply decorum. It's what's appropriate. In England they have to wear white wigs. I'm glad that we don't have to do that in the United
I had
States.
a Hague custody dispute once, and it was Calgary, Canada, and it almost went to a hearing, and they were going to require us to wear powdered wigs. And my wife couldn't wait for that. She was going to be there with a camera on, but I never had to go. We settled the case, and I think I was very motivated to settle the case because of that. Anyway, going back to the robe issue now. We will have the jurors will be instructed the law by you, correct?
That is correct.
And they'll be told what their roles are and all of that?
That's called a charge, and the jurors are instructed to listen very carefully to the charge, because the charge provides the jury with the instructions and the elements that they will need to make a decision in the case.
Your Honor, in this case, we had the preliminary hearing on October 28th, and part of the reason why we're filming this video is that we're going to have the trial either on February 23rd or March 23rd. We're going to resolve that in the next couple days, and we're going to have your video here help the children prepare to be we'll have a student jury.
Yes.
And we're going to have an adult jury too. So we'll have a student jury and an adult jury, and we're going to give them the benefit of your instructions and whatnot, and we'll have your instructions passed out by the teachers and things like that, but you'll actually coach them again just like you would in a trial.
Okay.
So anyway, having said that, we have the jury instructions, and you'll be the trial judge, and we talked about in the earlier segment on how part of your job is to run the trial.
Yeah, it's directing what goes on. A lot of what you do is administrative. It's determining when the trial is going to start. You talk about a presumption of innocence. Well, if a defendant is in custody, the jury is not permitted to see him in jail clothing, so he has to have on regular clothing. He's not permitted to appear to be in custody. He can't be shackled. With defendants who pose a danger to the community or potentially intimidating the witnesses, it takes a lot of preparation to make sure that the jury never finds out that the defendant is in custody, or that you've taken steps to secure the safety of the people in the courtroom and the court staff and the jurors while the trial is going on.
And there's things that take place. For example, everybody's assembled and then the jury comes in. The jury is sent out if you need to. And we're basically always trying to keep them from hearing anything that's not admissible.
That's not admissible, because if they hear something that's not admissible and it's prejudicial to the defendant, then it's a mistrial and you have to start all over again.
And the old expression, you can't unring a bell.
Correct.
And and that's part of like judicial conferences, and sometimes courts will say retire the jury, and then you might have a dialogue between both attorneys to find out, all right, what's going on, who said that and why, or what are you planning on doing with that?
And sometimes you can cure it by a curative instruction. So sometimes you can partially ring the bell if it wouldn't be too prejudicial or overly prejudicial to the defendant in doing so.
And that's your role. That's your
That's
job.
the discretion of the judge.
And then we'll have the closing arguments and whatnot. Now, I'm going to go back away from that because that's something that's not going to be the content of this video.
Yeah.
We're going to be able to do that later on some other manner. But for right now, we're going to focus as we close on the idea that years ago, the law changed on homicide by vehicle DUI related, correct?
Correct.
Do you recall generally what it used to be, what it changed to?
I can recall generally.
Again,
I don't recall the specific language, but it went to the causation of the accident, whether it was whether the DUI was the direct cause of the accident, or whether it was an element that led to it. The law became less specific as to causation of the accident from the DUI, but more specific that there was a homicide or a death that occurred.
So the Commonwealth has the burden of proof
Yes.
for all elements
The
at all
Commonwealth
times.
always has the burden of proof of each and every element for the offenses charged.
And the burden of proof is beyond a reasonable doubt.
Correct.
There's three different burdens. There's in civil trials, we have preponderance, which is the slightest.
Yeah, if you think of an ordinary balance scale and you place all the evidence favorable to the plaintiff on one side, all the evidence favorable to the defendant on the other, if the scale tips ever so slightly in the favor of the plaintiff, then the plaintiff wins the case. If the scales are equally balanced, or tip in favor of the defendant, then the defendant wins the case.
And I want to caution everybody who's watching our video here that, as we indicated, we're in a very lively area over here. We're sharing the space with people who are having lunch and whatnot. So I promise to keep my voice up so that you can hear this. And we're not going to be distracted by that, because this is part of what we're doing. It's a real life application. So burden of proof, beyond a reasonable doubt, okay? And we know that in civil cases, it's slightest preponderance. We have a different series of cases that are called clear and convincing evidence,
Yes.
which is a little bit more strict on the burden party than preponderance, but not as far as criminal, correct?
Correct. And an example of clear and convincing would be a termination of parental rights,
Okay. And-
involuntary termination of parental rights.
So we are in the highest standard there is.
Yes,
Criminal case, the government versus a citizen of the United States.
yes,
And the Commonwealth bears the burden at all times,
at all times.
the highest burden possible.
Yes,
Now, taking that, okay, taking that highest burden, the government needs to convince 12 jurors beyond a reasonable doubt that the DUI, alcohol, caused the death of this person. Am I saying that right? Probably not.
generally right. The instructions will be more specific than that.
Okay, so the instructions will take care of that. But in the beginning, you indicated that the law was less burdensome for the Commonwealth, correct?
The newer version of the law is less burdensome than it was in the 1980s.
Oh, so in the 1980s,
It was in the 1980s was Pennsylvania first enacted, the legislature first enacted homicide by
this
vehicle.
is such a critical detail. I want to make sure we get it.
While driving intoxicated. And the law has evolved, as most laws do. The legislators update them and change them. So there have been updates and changes that have essentially made it easier to get a conviction of homicide by vehicle while driving intoxicated.
So in the old law, it was more difficult.
It was more difficult to get a conviction.
So you had to prove that beyond a reasonable doubt, that the alcohol caused the death.
Yes.
The collision,
The
basically.
collision.
Okay.
Yeah.
So now it has evolved and it's easier on the prosecution.
Yes.
Okay, so they only need to prove what now?
That you were guilty of DUI and that a death resulted from an accident.
Okay, so if you prove your DUI
Yes.
and you prove that a death resulted from the accident,
Okay, let's go to an example
Yes.
of a one-vehicle accident. This is a case I actually had. High school boyfriend and girlfriend. And he's intoxicated, and he drifts off the road and hits a tree. He lives, and she's killed. So, in that case, the elements, if they establish beyond reasonable doubt that he's intoxicated, leads very much directly into homicide by vehicle while driving intoxicated. You can be driving down the road and at night, and a lot of people have accidents that aren't intoxicated. So the elements in that case were very easy to establish.
and had it been back in 1980, would that have been different?
It would have been, there would have been an extra element for the Commonwealth to establish that there was a causation issue.
Some defense attorney would argue he fell asleep or
Correct.
something like that. Okay, so now I get it. It's subtle, but it's an important change. Now, in this case, and Mr. Lindsay asked questions about this toward the end of the preliminary hearing. In this case, the driver will look over to somebody who calls him to look at a camera
Yes.
at the impact moment. And I would think, and I don't know this, but I would think the defense attorney would claim that that was an intervening cause of some sorts that now excuses the alcohol connection.
It's that
In that particular case, that might change the scenario because there might have been intervening cause.
there may have been an intervening
that
cause.
some other
correct,
person
that would-
caused him to look right, and it wasn't the alcohol.
Yeah.
If a juror gets that, I'm just creating a hypothetical, and the juror says that the Commonwealth of Pennsylvania did not prove beyond a reasonable doubt that that young lady didn't cause him to look rather than the alcohol,
Yeah.
I think that would be the defense argument.
Okay, so can I digress and
Yes,
give you a
absolutely.
story that you may not want to put on? So the outcome of this case is horrible. I still don't sleep well with it. So the district attorney in the case, since the defendant was 17 when the accident happened, but was months away from his 18th birthday, made an election to prosecute him as an adult. So there were two elements going on. He recognized that his actions, either directly and criminally or maybe not, caused the death of his girlfriend, and he was greatly disturbed by that. And the district attorney decided that he should be prosecuted as an adult. And as presiding in juvenile court at the time, the district attorney made the motion, and the defense attorney did not object because he thought that he would have a stronger argument before a jury than he would have before a judge hearing the case. So I had no discretion but to let it be treated as an adult. So anyways, he left the courtroom that day on bond, a bond that was agreed to by the defense attorney and the district attorney. He went home, put a gun in his mouth, and pulled the trigger.
Wow.
So
The defendant.
the defendant,
And how old was he?
he was 17 at the time. So, you know, he was overwhelmed by the consequences of what he was facing. I don't agree with his attorney that he made the right decision. That
I definitely disagree too, yeah.
yeah. So I think a combination of the guilt of having killed somebody. And I know other people. I know an attorney in Butler who has an older brother who, at a young age, not as a juvenile, but as a young age, went to a bar, was intoxicated in an accident, and killed somebody in the accident. And everybody, it's a large Catholic family, everybody in the family has been very successful but the brother who did that, and he's never been able to forgive himself. And he is now in his 70s. He was able just kind of to barely make it through life, but he was never able to forgive himself for taking somebody's life in such a manner, and it destroyed his life.
Wow. What's going to happen now is we're going to have the trial, and you're going to be the presiding judge,
Yes.
and we've tried to protect you from advanced knowledge as much as possible. And it's real life.
Yes.
And they'll make the arguments. We'll even have them meet with you.
Yeah.
And whatnot. Is there anything you want to tell teachers, parents, doctors, lawyers, why you think it might be valuable for them to attend this event?
Well, you need to attend it for several different reasons. I'm going to use myself as an example. The people that you're dealing with, your kids, your students, they could be the ones that sit and listen to this and become inspired, and they're the leaders for this community in the future. So it's very important. This may be the motivation that they need to go on and continue, because somebody in our community has to go out 4 years of college, 3 years of law school, and come back and be prepared to direct our community and provide justice. The other thing is you need to take this as an opportunity to address the issues that are raised. The issues are cell phone useful in a car. The issues are becoming intoxicated and being responsible. And the consequences of those can go on for life, or they can terminate your child's life or your student's life. It's the nature of being young to think that this stuff is never going to happen to you. But after having sat through 30 years of court with juvenile court, I can tell you that it does, and it happens constantly. And the most important thing is that you raise these issues, you discuss them on a regular basis, and you find a reasonable ground that you can accept as a parent and your child can accept. I'll digress a little bit. There's something that I referred to as Roseanne parenting, if you remember the TV show that was on years ago. It's not appropriate to correct your kids in public. It's not appropriate to nitpick at them. You have to have meaningful conversations with them and to raise these issues before they come up in real life so that they are prepared to deal with them. As I said before, it's the nature of being young to make mistakes. And we need to counsel our kids to be hopefully lucky enough to live through their mistakes and smart enough to learn from them. It's a trial and error process to grow up. It is so critical, and so critical to have appropriate direction from parents, from teachers, and from community leaders to do all this.